Hello and welcome to the WIHS Journal Public Affairs program. I'm Gerry Williams. Well, recently I was out and about attending a workshop on the fundamentals of intellectual property protection, headed by Jennifer Kowcani of Carmody, Torrance, Sandak, and Hennessy, LLP. You'll hear my conversation with Jennifer, as well as audio clips from her workshop. I started off by asking her, what is intellectual properties? And she said,
intellectual property is really anything that you come up with it's not real property, it's anything that's in your head. It can be a patent, which is kind of a new invention. It can be a trademark, which is basically symbolizes your company. It can be a copyright, which is, the words or kind of a painting or something that, words on a page.
And speaking of patents, what exactly is a patent?
Well, a patent is really a contract with the government. A patent is really a right of exclusion. So having a patent doesn't give you the right to make, use, or sell your invention. It gives you the right to keep others from making, using, or selling your invention without permission. So basically, in exchange for your disclosing your invention, you have a right of exclusivity, which is 20 years from the filing date of your application.
So why does the government grant patents? The government grants patents really to encourage innovation, to incentivize inventions. So it's a temporary monopoly in exchange for you disclosing it. So really, to get a patent, you've got to disclose how to make, use, or sell it. And in return for doing that, you get this monopoly for this period of 20 years. Design patents is 15 years. Patents are worldwide, but your patent is only good in the jurisdictions where you file for. So, if you have a U.S. patent, you cannot stop somebody from making the product in China. You can stop them from importing it from China into the U.S., but you cannot stop them from making it in China, unless you also have a Chinese patent.
There are many different types of patents. Talk about some of the different types of patents.
Sure. There is a design patent, which protects the ornamental features. So you may have a design patent, for example, for the tread design of a tire or like a face of a watch. And then you also have a utility patent, which what it says, it protects the functionality. So you may have a utility patent for a new product you've developed.
Typically, how long does it take to get a patent?
That is kind of up in the air. I would say in the U.S., you're looking at probably 2 to 4 years to get a patent. But it just really depends. There is still a backlog at the patent office. While they've been working and the time has certainly come down, 2 to 4 years is probably a good time estimate.
Frequently asked questions. Is our invention patentable? Is it marketable? Where should we protect? Which invention should we patent? And how long will it take to get a patent? So, is it patentable? If you have a small company or if you have a company of any size, one of the biggest things you can do is to have an invention disclosure form so that if somebody is putting something down, you have a written record of it, and that you're also asking them to let you know what they know about it and what prior art they may know about, how did they come up with it, who did they disclose it to, any sort of peer review, again, within your company to challenge each other. You're going to end up with a better patent if you can challenge each other. Well, why did you do it that way? What else could we do? How can we do this? The other thing is prior art searching. And prior art searching can be both an online search at, say, the Patent and Trademark Office, which you can do yourselves, or it can be an outside search that you'd ask an attorney or another outside search firm to do for you. Sometimes it's good to do like a quick search yourself so you can find out what's out there and have a better sense before you go and talk to an attorney about it.
If you're just tuning in, I'm with Jennifer Kowcani of the law firm of Carmody, Torrance, Sandak, and Hennessy, and we're talking about patents and intellectual properties. What are maintenance fees? I heard something about maintenance fees. Talk about that.
Sure. So maintenance fees. So if you get a patent, you have to pay to maintain the patent. So in the U.S., you have to pay maintenance fees at 3.5, 7.5, and 11.5 years after your patent has issued.
What's the difference between a copyright and a patent?
So a copyright simply protects how the words are arranged on the page. So if you've written a book, you're going to have a copyright for the book. So basically what those words are and how you've arranged them on the page. A patent really is protecting how something functions.
Inventions and innovations are covered by patents. Designs and logos are covered by trademarks. Literary and artistic works are covered by copyrights. And then there's also the issue of confidentiality when you get into trade secrets and other ways of maintaining the secrecy of your property.
Jennifer, do you yourself have a patent on anything?
I do not have a patent on anything. I am always amazed at how creative people are. I've been doing this for 17 years, and it amazes me the creativity people have in coming up with something new.
Talk about your background. How did you get started in this?
Well, I have a chemical engineering degree, and I actually went to law school figuring I'd do environmental law, and ended up taking a job at the patent office and worked as a patent examiner for a few years. And then my family is from New England, and I wanted to get closer to home, so I landed in Connecticut.
There's a big distinction between what is patentable, meaning is it something that is new and non-obvious and meets various criteria for patentability, versus do you infringe somebody's claim? And I say that, and I'll use one example that I like to use. So we'll say that you invented the pencil. The pencil is brand new, and you're able to get a patent on a pencil. So no one else can make, use, or sell a pencil without getting your permission. Somebody comes along and figures out that, I can put an eraser on top of the pencil. Well, they could get a patent on a pencil with an eraser because the eraser is an improvement on your pencil patent. However, they could not make a pencil with an eraser because they'd be infringing your underlying patent. But you also couldn't make a pencil with an eraser because you'd be infringing their patent. That's when you start getting into the licensing.
A situation or an example that because someone didn't get a patent in a timely fashion, they lost out in a major way that stands out in your head.
Oh, good question. I had a situation one time where somebody had tried to get a patent themselves, and they really had not followed through on the paperwork with the patent office. So when they came to me to try to fix it, it was several years after the fact, and I had to tell them that, you can't, there's nothing I can do, because they had lost all their rights because they hadn't prosecuted it properly. So that happens sometimes, but there are also sometimes people may have a really good idea that it's not patentable. You may have come up with a really, what you think is really unique, but while it may be a great idea, it may be something that the patent has long since expired. So it may not be new, it may not be non-obvious, but you still may be able to use it. So, sometimes to me, there's a difference between is it patentable and is it a great idea.
And in closing, something from the heart that you would like to convey to our listening audience concerning intellectual property and or patents.
Patents are fun. This is creative writing. This is a way of being able to secure something for somebody. And somebody once told me this is one of the few areas of the law where people come to you because they want to, not because they have to. So usually people are very happy to be getting a patent or a trademark or a copyright. This is something people are excited about. And I think that's what makes my day and my job fun.
Jennifer, thank you for taking time out to share with us in your field of expertise on the WIHS Journal. God bless you.
Thank you very much.
If you would like more information about what you heard today, call WIHS 860-346-1049, 860-346-1049. The opinions expressed are those of the participants, not necessarily of those of the staff or management of the station. I'm Gerry Williams for the WIHS Journal. It's news and public affairs.